At first glance, it looks ordinary. Cities at night, flights in the air, documents on desks. Nothing here announces a crime. And that is precisely the point. Power rarely moves in the open. It moves quietly, through systems, institutions, and sealed records. You're watching the Epstein Files documentary. Over the years, court filings, flight logs, and sworn testimony have drawn intense public attention. They are often grouped together under a single phrase, but these records are not one document, not one list, not one narrative. They are fragments from civil cases, criminal proceedings, and investigative reviews, released slowly, sometimes years apart, often without surrounding context. Names appear in depositions. Names appear in contact books. Names appear in travel logs. But appearance is not confirmation. Context defines meaning. And without context, interpretation becomes speculation. Maps show routes across continents. New York, Florida, Paris, remote islands in the Caribbean. Private jets crossing borders without scrutiny. Travel suggests access. Access suggests proximity. But proximity is not participation. And participation is not proof of crime. Investigations distinguish between presence, association, and culpability. That distinction is critical. Thousands of pages exist. Court transcripts, affidavits, exhibits, motions. Many are heavily redacted. Black bars replace names. Entire paragraphs are removed. Some records remain sealed to protect identities or ongoing proceedings. The public record is vast, but it is incomplete. What we see is a legal snapshot, not the entire archive. Why records were sealed? Sealed documents often create suspicion, but in legal practice, sealing can serve specific purposes: to protect victims from exposure, to prevent prejudicing juries, to safeguard due process. Courts weigh transparency against harm. Sealing is not destruction, it is restriction, and restriction can be temporary. Over time, some records are unsealed. Others remain protected. The process moves slowly, but deliberately. Institutions and accountability. Investigations involved multiple agencies, federal prosecutors, field offices, interagency coordination. Cases were reviewed more than once. Some matters were closed, some were reopened, some remain under examination. Institutional response rarely unfolds in public view. Grand jury proceedings are confidential. Internal reviews are procedural. Evidence collection follows strict standards. Public perception moves quickly. Legal systems do not. Accountability within institutions requires documentation, corroboration, and admissibility. Press conferences may be brief. Court filings may be dense, but legal outcomes depend on what can be proven, not what is rumored. And that difference often determines whether a name remains a mention or becomes a charge. Why this matters. This story is not about spectacle, it is about systems, about how power intersects with law, about how transparency interacts with protection. Understanding the difference between allegation, association, and conviction is essential, because public discourse can blur those lines. The courts cannot. When justice moves slowly, questions remain. When records surface gradually, patience becomes necessary. And when facts are complex, clarity requires restraint. If you value calm, fact-driven documentary storytelling, subscribe to my channel. Your comments guide future investigations. Your engagement shapes what we explore next.